Hey, I got a question for you. At some point in school, right, you learned about the constitutional amendments that followed the Civil War or the Reconstruction Amendments, 13th, 14th, and 15th, to end slavery and establish equality before the law, allow black men to vote. Now, another chapter, of course, that you cover is the civil rights era of the 1950s and 60s. Brown v. Board of Education, Rosa Parks, Martin Luther King, Civil Rights Act of 64, Voting Rights Act of 65. These are huge turning points in civil rights and especially for African American opportunities. Now, my question is, if we learned about those Reconstruction Amendments, why do we need to learn about the civil rights era of the 1960s? Why did the civil rights era need to happen at all? The 14th Amendment forbids discrimination, right? It affirms privileges and immunities, insists on equal protection. But 100 years later, activists are fighting and dying to end racial segregation and exclusion from schools and voter suppression. Furthermore, much of the discrimination was legal until the civil rights legislation of 64 and 65. And that seems to really contradict the 14th and 15th Amendments. So what happened in between to make racial discrimination not just common, but lawful? Now, to understand, we must see how the Supreme Court interpreted the Reconstruction Amendments. From the 1870s to the 1890s, the court interpreted the 14th Amendment especially in a way so that it eliminated the impact the writers intended. Interestingly, though, the first case affecting the 14th Amendment, the Slaughterhouse decision of 1873, did not technically involve race discrimination at all. Yet it devastated the prospect of racial equality in the foreseeable future. The case specifically dealt with state regulations over public health and sanitation. In New Orleans, 1,000 butchers annually slaughtered over 300,000 animals north of the city on the Mississippi River. They disposed of the blood and guts and all the filth right in the river, which runs south right through the city and into the drinking water. All this rotting waste flowed into the streets and in the drinking water of New Orleans, causing horrific outbreaks of cholera and yellow fever, killing thousands of people every year. According to one observer, New Orleans history was one long, disgusting story of stagnant drainage, foul sewage, and filth. Endless filth everywhere. So, in 1869, the Louisiana State Legislature passed a law restricting the slaughter of animals to south of the city and established the Crescent City Livestock Landing and Slaughterhouse Company. Now, if you wanted to butcher in New Orleans after this, you would have to rent space in their premises and be subject to their regulations. But some butchers complained that it put them out of work. There wasn't enough room to work in this new company for everyone. So a group of 400 butchers sued the state, claiming the slaughterhouse law violated their 14th Amendment rights. Now, let me try to make this as clear as possible. The butchers' claims were unrelated to race. But these white men wanted to use the 14th Amendment, which had meant to protect blacks, to their own benefit. And just because the specifics are not racially based, it doesn't mean that it's not well within the racial contest going on at the time. Remember, this is during Reconstruction when the U.S. Army is down there at gunpoint enforcing black rights and black voting. And a full 1/3 of the state house is made up of black men. These are the same men that helped to pass this Slaughterhouse law. And so many whites just look at all of the laws that this government passed, no matter what, as detestable. Some Southern whites saw the Slaughterhouse lawsuit as just one battle in an overall war to negate everything that Republicans did. According to the New Orleans Bee, the laws of this government were of no more binding force than if they bore the seal of a Haitian Congress of human apes. Oh man, I can't believe this. The butcher's attorney, John Campbell, was an ex-Confederate who despised the thought of racial equality. Campbell is hoping that the court will interpret the amendment as saying, there are a lot of sacred rights, like being able to perform your trade, that come along with American citizenship. And the 14th Amendment declared that states cannot restrict those rights. Now, to be fair, that's not an unreasonable argument. Nevertheless, the court decided against the butchers, insisting that the 14th Amendment had not expanded rights that states were powerless to restrict. That was bad for the butchers in this case, but on a much bigger scale, it was even worse for African Americans in general. Now I hear you saying, hold on, how can a decision against a bunch of races be bad for these black people? Now, good question, and here's how. Their hopes at the time was that the court would interpret the amendment as establishing a wide view of American rights that states could not violate, just like John Campbell, attorney, and that the federal government would be the protector of those rights. You see, black people and their supporters realized that white supremacists are eventually going to take back over these states. And when they do, African Americans are going to need the federal government to protect them and their basic rights from the state government. However, the court expressed the exact opposite view. In fact, Justice Samuel Miller declared there were two distinct types of citizenship mentioned in the 14th Amendment. That's U.S. citizenship or national citizenship and state citizenship. Now, the amendment, Miller wrote, only prevented states from restricting the privileges and immunities belonging to national citizenship. You might say, well, okay, that's fine, that's good. But then he goes on to say that what actually consists of national citizenship is just a very few things like running for federal office, navigating the interstate waterways, and protection while you're on the high seas. Now, if the state prevents you from navigating rivers or sailing on the high seas, you can count on the federal government. You're all good. Cha-ching. Otherwise, it's out of their jurisdiction. Everything beyond those narrow rights were state matters, and it was perfectly within the powers of the state to limit a person's occupation when in the state's interest. So while this was a loss for a specific group of white butchers, it was a win for white supremacy and a terrible loss for African Americans who, just barely out of slavery, would soon be abandoned by the federal government. In concluding that there were two distinct types of citizenship, national and state, and insisting that national rights were so narrow, they prevented the federal government from stepping in and protecting African Americans against abuse. Because the Slaughterhouse decision set the precedent that damn near everything was beyond the jurisdiction of the federal government. And remember, this is a time when the vast majority of black people still lived in the South, where much of the white population were still angry and resentful over losing a war and suffering what they considered to be the indignity and shame of Reconstruction. Now, Slaughterhouse opened the door for many to simply unleash their pent-up rage without any fear of justice.